This next subject matter we're getting ready to talk about, estates and land. This is one of these sections or areas of real estate that we could get kind of deep in the weeds if we're not careful. So we're not going to do that. Reason I say, when we start talking about different types of estates, what we're referring to is there's different ways you can own real estate. There are different types of ownership rights and things of that nature. And we're going to get into some of the different ways, obviously, you can own real estate. That's kind of important if you're going to be in the industry. Now, having said that, and this is important to understand, we are not estate planners, okay? So should we as real estate agents ever try to advise our clients on how they should own real estate? No, that is not the intent here. What we want to understand really is just some terms and definitions, because you're going to be hearing these terms quite a bit and from time to time while you're practicing real estate. Well, it's very useful if you hear some of these terms, you at least know what we're talking about, right? No one expects you to be the expert. Again, you're not the attorney, and you're certainly not the estate planner. So you won't be advising, or you should not be advising any clients on what they should do or what they should consider when buying or owning real estate. Now, hopefully you'll have enough information through this module that at least you can kind of help your clients know what questions to ask the right person, okay? You don't need to be the source of the information because you're not going to be smart enough. Well, y'all say smart enough. Not saying you're not smart, but you won't have enough knowledge and understanding of this subject matter to try to give any advice. So you don't want to do that. You need to just help them come up with the right questions to ask so that they can make the right or an informed decision for themselves. Okay? So, when it comes to estates and land, or estates or ways you can own the land, there's two primary types of estates. It's either going to be a freehold estate, and if it's freehold, you'll notice it says that means you own it. Freehold means ownership. You own the property. But another type of estate we're going to be talking about is called the non-freehold, or a lot of times you'll hear it referred to as a leasehold estate. Well, if you own a non-freehold estate, then that means you are renting or leasing the property. Okay? Now, this is important to understand. You still have ownership interest even though you're the tenant. And we're going to break this down and talk about it. I know that sounds weird. How can the tenant own property? Well, we'll talk about it as we go through. They may not own the property, but they do have some ownership interest, and we're going to talk about all that. So again, two definitions right here. What's a freehold estate? That means you own it. So if you bought a house, you own it, then you own a freehold estate in that property or in that house. If you rent the house, then you own a non-freehold interest or a non-freehold estate, or sometimes called, again, leasehold. So those are the two primary types of estates that we're going to be talking about. Now, before we get any deeper, here are 4 terms that you're going to hear used quite a bit as we go through this module. So let's go ahead and get some terms and definitions out of the way right here. Number 1 is tenancy. Now, this is a term that actually has 2 completely different definitions, depending on the type of estate you're referring to. So, this is one you want to be careful with, at least certainly for test purposes, to keep them straight. So what does tenancy mean? Well, if you're talking about a freehold estate, remember we just said freehold means you own it, then tenancy just means how the land is held. In other words, is there just one owner of the property, or are there multiple owners of the property? Because I will tell you that matters a lot, as you'll see as we go through. But that's what tenancy is referring to with freehold estates. Now, if you're talking about a non-freehold estate or leasehold, now tenancy has a completely different meaning. Here, tenancy means length of time or duration. So, two different definitions for the same term. The second term you see there is interest. You'll hear that term a lot, quite frankly, like if you own any interest in real estate. Well, if you do own interest, then that interest just means that you have acquired what we call a bundle of legal rights. That's what interest means. So if you own interest in real estate, it comes with the bundle of legal rights. And we're going to break all those down to make sure you know what those rights are. But, for example, you have the right to use, control, possession, disposition, quiet enjoyment. There are some legal rights that come with ownership, and that's what makes up your interest. All right. The third term you see here is the word fee. Fee just means it's inheritable. So any type or any kind of estate that you own, if you see the word fee, for example, like fee simple or fee simple absolute, defeasible fee. We're going to be talking about all these different types of estates. But any of these estates that have the word fee, that just means that whatever it is you own, it's inheritable, meaning you can leave it to your heirs when you die. That's what fee means. And then title, just proof of ownership. If I hold up title to property, that's my proof or evidence that I own the property. That's all title is. Okay, so we've got those terms defined. Now let's start out talking about, there's two primary types of freehold estates. There's two of them, and we're going to talk about them. But what did we say freehold meant? Ownership. It means you actually own the property. Okay, well, there's different ways you can own property. And the first way is by fee simple absolute. And obviously, as you see here, this is the highest degree of ownership recognized in this country. So my assumption would be this would be the most preferred way to own property, at least by most people. Now, I'll tell you it's not the case all the time. We're going to talk about other reasons here. But most people want to own or have the highest degree of ownership. Well, what makes this the highest degree of ownership? Well, let's look at the name of the estate, fee simple absolute. Well, if I own the property in fee simple absolute, could I leave it to my heirs when I die? Hopefully you said yes, and the reason you know that is because you see the word fee. Remember, we just said fee means it's inheritable. So yes, you can leave it to your heirs when you die. But then you also see the word simple. It means this estate is simple. It's uncomplicated. In other words, there are no restrictions on what you can or cannot do with the property. You own it outright, and you can do whatever you want to do with that property. Okay? No one has put any restrictions to prevent you or keep you from doing anything you want to do with it. So that's the fee simple absolute. It's pretty simple. But then another type of estate you could own, or is a defeasible fee. Now that's another freehold estate. Again, you still own the property, but this time as defeasible fee. Well, if I own an indefeasible fee, can I leave this to my heirs when I die? Again, hopefully you said yes, because you see the word fee. Fee means it's inheritable. But what word is missing if you compare it to the last estate we just talked about? Which word is missing? Simple. Y'all, you notice the word simple is not in this one. And for good reason. Y'all, defeasible fee estates are not that simple. They are more complicated. Well, what makes it complicated? Restrictions. That means whoever you bought the property from, or whoever gave the property to you, whoever you received it from, put restrictions on what you could or could not do with the property. Okay? Now, a couple things real quick. And I tell every class this, if you can just remember this, and for some reason this is not something that absorbs into our minds very well, apparently. I don't understand why this is so hard to get. But just do your best to remember this. Anytime you see or hear that word defeasible, the first thing that should come straight to your mind are restrictions. Because that's what you're dealing with. Anytime you see that word defeasible, what's the first thing? Restrictions. I know there's going to be restrictions we're dealing with here. All right, so what are we talking about? What kind of restrictions are we talking about? They can be anything. I mean, whoever sold you the property or gave you the property, they may try to restrict you from doing something with or on the property. And as long as it's not illegal, obviously no one can put an illegal restriction and hope that be enforceable. You can't do that. But as long as it's legal, you have to comply with whatever the restriction is. And I will tell you, a lot of times, if you read enough of these deeds, which, by the way, where do you find the restriction? So if a restriction exists, where would I find it, and where would I know what the restriction is? It's in the deed. That's where you're going to find it. And I will also tell you, once a restriction is put in the deed, it stays there. It cannot come back out. So that means it would apply to every person that ever owns that property all the way into the future. Because that restriction stays with the property. The only person that can ever remove a restriction from the deed is the person that initially put the restriction there. So obviously, if someone puts a restriction in the deed and then later dies, that's it. The only person that could have taken it out is now dead. So that restriction will stay in the deed from now on. And whoever owns this property from now on will have to comply with whatever restriction it is. Now, sometimes it might be a restriction that really has nothing to do with a different owner. But a lot of times it does. In fact, most of the time it does. Just for example, I might sell the property or give this property to somebody, and I put into the deed that you can never allow alcohol on this property. Now look, you may not like that restriction, you may not agree with that restriction, and it really doesn't matter. You have to comply with it. Because if you violate the restriction, you will lose ownership of the property. It's gone. You no longer own the property. Y'all, I want to make sure you understand what I'm saying here. These restrictions, you just can't decide in your mind because you believe it's stupid that I'm not going to comply with it. The moment you violate a deed restriction, you have lost ownership. You no longer own the property. Now the question now is, well then what happens to the property if the restriction is violated? And we're going to talk about that. But I got to tell you, this is one of the things that's very critical for real estate agents, You need to review the deed to a if you're representing a buyer, get a copy of the deed. It's public knowledge. Most deeds, I won't say all, but most deeds you can probably get online. You don't even have to leave your office, or maybe don't even have to leave your home. You can pull it up online, print it out, read it. Now there may be some, depending on how old the deed is, you may have to go to your county, to the Register of Deeds, and actually get a copy of it. It may not be online if it's been too far back, but most of them I think you'll find nowadays are online. Make sure there's no restrictions in the deed, and if there are, you better make sure your buyer's okay with it, because if it's something they can't live with, you probably don't want to buy this property, because again, if you violate the restriction, you lose ownership of it. You will not own the property. So that's a big deal. All right. Now, so again, the question now is, well, what happens to the property? I know I just said if you violate the restriction, you lose ownership. Well, now who owns it? What happens to it? Well, that's what we want to talk about right here. There are different types. There are 3 types of defeasible fee estates. Remember we said defeasible means restrictions. Well, depending on which of these 3 types of defeasible fee estates we choose to go with, that will determine what happens to the ownership of the property. Okay? So let's take a look at the 3 options we have. One is, again, fee simple determinable. Again, we're not trying to make you the expert here. You're not an estate planner. You're going to be a real estate agent. So we just want you to be somewhat familiar with some terms, right? Definitions. And the next term you see is fee simple determinable. All that means is there's an automatic reversion of interest right back to the grantor. So if someone that buys the property or receives the property, if they violate the restriction, the ownership automatically reverts right back to the person that you bought it from or received it from. It's automatic. That person does not have to file any kind of paperwork or take any kind of legal action. It's just automatic. You violated a restriction, boom, it's gone. It's just that simple. All right, so that's the fee simple determinable. Well, you may choose to set this type of estate up as a fee simple subject to a condition subsequent. Condition subsequent just means there's no longer an automatic reversion of interest. It's no longer automatic. Now the grantor or whoever, or maybe the grantor's heirs, now they would have to actually take some legal action to get ownership back. But let's be perfectly clear. The question's not will they get it back or can they get it back? They will get it back if you violate the restriction. The only question is when and if they choose to file the action to take it back. Okay? So under condition subsequent, it's just no longer an automatic reversion. It's now basically up to the grantor or their heirs to file an action to take it back. But just be clear, if they decide to do that, they can and they will get it back. All right. So that's the condition subsequent. But then the third one is the fee simple with an executory interest. Executory interest means the grantor has not just named their heirs, or has it set up so that their heirs would receive it back if the restriction is violated. They actually named a person or group or whatever or whoever to receive the property when and if the restriction is ever violated. Okay? But now with this one, again, there is still the automatic reversion. So again, it's automatic. Y'all, so if we set it up executory interest, you violate the restriction, boom, it's gone. Who's it go to? Whoever they named in the deed, y'all, as the executory interest to receive the property once the restriction is violated. Y'all, just to give you an example, sort of what we're talking about there, y'all, a common example would be, y'all, say you've got a person that owns a vacant lot or some vacant property adjacent to a hospital. And they really like this hospital because they're doing some really good things. They're helping a lot of sick people out, obviously. So the owner of this vacant property decides to just donate, to give the property to the hospital. But they put a condition on it. And the condition is, hospital, this property is now yours as long as you continue to use this property for hospital purposes. In other words, you better always use it for hospital purposes, because if you ever use it for any other purpose, then it will automatically revert to John Doe. They actually named someone in the estate to receive it if the hospital tries to do anything else with that property. That's an executory interest. They named a third party specifically in the deed to receive it if they violate the restriction. Okay? So obviously 2 of those 3 options we just looked at here, have automatic reversions of interest. It's just one of them, the fee simple determinable, automatically comes right back to the seller or grantor. The other one is the executory interest, which again has an automatic reversion, but here they named a third party to receive it. Instead of it coming right back to the grantor, it goes to some third named party. But if they went with the condition subsequent, then there's no automatic reversion. It would just require the grantor or their heirs to take some action to take it back if they choose to do so. Okay? So, those are your 3 options under the defeasible fee. And we talked about 2 different types of freehold estates. The fee simple absolute, and then this one, the defeasible fee, which means there are conditions or restrictions that must be complied with throughout the ownership of the property. Okay?